Good afternoon. Welcome to today's TASA webinar, Airports and Compatible Land Use Planning. During today's program, our presenters will cover the following: key legislative background, the role of federal and state aviation agencies, understanding industry nomenclature, airspace and aircraft noise perspectives, the aviation industry, land developers, and the general public, the role of the legal profession, interpretation of federal and state regulations, identification of opportunities for compromise and mitigation, and litigation when necessary. The presenters for today's program are Ronald Price and Henry Young. Ronald Price has 39 years of experience in airport and aviation consulting. He is principal of QED Airport and Aviation Consultants. Mr. Price is a nationally recognized expert in airport facility planning and development, airspace analysis, instrument procedure design, and obstacle evaluations. His clients include airport owners, airport operators, state aviation agencies, land developers, wind turbine farm developers, and attorneys. Henry Young has 38 years of experience in compatible land use planning and environmental analysis for airports and heliports. Mr. Young is president of Young Environmental Sciences Incorporated. He is a recognized expert in airport environmental planning and impact assessment, noise abatement planning, and airport and heliport planning. His clients include federal, state, and local governments, airport operators and proprietors, law firms, land developers, and private organizations. We will take 2 question and answer breaks during today's presentation. If you have a question for either presenter, please submit your question by using the chat feature, which is found on the right-hand side of the screen. We encourage all attendees to submit questions throughout today's presentation. Tomorrow morning, I will send out an email with a link to the archived recording of this program, as well as a copy of the PowerPoint presentation that we use during today's program. I now invite you to sit back, relax, and enjoy. I'm going to turn the presentation over to our distinguished guests, Mr. Ron Price and Mr. Henry Young. Ron, the presentation is now all yours.
Thank you very much, Matt, and welcome to all of you to the webinar. Our webinar is comprised today of 6 components. Let me get to the right slide here. And the first is going to present an overview of the webinar and how the topic of airport land use and compatibility planning relates to you as a profession, as an attorney, and to your clients. We're going to highlight some of the key legislative aspects, give you a bird's eye view of the airspace structure in the United States, particularly as it relates to the vicinity of airports. We're going to discuss how aircraft noise impacts are assessed versus how they are perceived. And then we're going to have a question and answer session after each major topic area and offer some concluding comments. During this webinar, we want to convey some of the key legislative aspects and factors that you as attorneys should become familiar with. As you might imagine, there's a lot of technical jargon in the aviation industry, as there is in your profession. Nearly every other word we use is an acronym or an abbreviation, but we hope that during this seminar you'll pick up on some of that jargon. We also want to give you the impressions of others as they deal with airspace and aircraft noise issues with respect to land development. And we also want to identify the role that you as attorneys representing your clients have in getting the message across and interpreting the regulation, finding ways for compromise and if necessary, establishing a legal argument. I guess this thing can move forward here. Okay. So while there are a number of regulations and case law that you could spend hours reviewing, this slide and the next one list some of the relatively more important ones with which you should become acquainted. Perhaps the most significant legal case that can provide insight to the issue of aircraft noise impacts goes back 50 years, when the new airport serving Pittsburgh was constructed and became operational. This ruling involved Griggs, a local resident, against Allegheny County, the owner of the airport, and through the judge's ruling established the key premise that the airport owner bears the responsibility for the noise impacts that aircraft using its facility generate on the local community. You also need to know the difference between whether an airport is obligated or not. Obligated airports are those that accept federal grants for capital improvements. You also need to be aware of whether the airport is publicly or privately owned, because this helps establish the extent to which federal laws and regulations apply. Grant assurances are the strings that come attached to funds provided by the federal government for capital projects. These grant assurances can run to perpetuity when the funds are used to acquire land or aviation easements. Otherwise, they run for 20 years or the life of the project funded, whichever is greater. Some of the key regulations and issues addressed by these grant assurances are shown in the sub-bullets. If you want to engage in some interesting reading, download the grant assurances from the Federal Aviation Administration website. That might make you wonder why an airport would ever accept $1 of grant funding. Here's a listing of some other key legislative acts and how the FAA interprets them for or uses them for interpretation and implementation and enforcement in their orders. And orders are the documents that guide how they conduct their business. As one reads these acts and orders, it becomes clear that the FAA is in the business of promoting airports and their use. Illustrative of that predisposition is the fact that only one airport in the country has successfully responded to the challenges of implementing aircraft access restrictions through FAR Part 161, and that was Naples, Florida. You might note that they spent nearly 6 years and $10 million to accomplish it. Now on to some of the technical issues that you and your client should be aware of. First is Federal Aviation Regulations, FAR Part 77. This regulation defines the process through which the FAA is notified when an object is to be constructed in the vicinity of an airport. If the object penetrates any one of several imaginary surfaces associated with the runway, it is classified as an obstruction. Depending on the severity of that penetration, the obstruction could be determined by the FAA to be a hazard to air navigation. You should note that not all obstructions are hazards, which is why you see lots of red lights on structures and adjacent to trees around airports. FAR Part 77 defines imaginary surfaces named as the primary, approach, horizontal, conical, and transitional. These are three-dimensional and vary in size and shape based on the types of approaches to each runway end. Those that are precision approaches, that is with vertical and horizontal navigational guidance, have more restrictive dimensions. All the dimensions and features described in FAR Part 77 are fixed by the regulation. There is no room for intentional misinterpretation. It is very clear-cut. An important technical factor here is that the imaginary surfaces are based on the physical length of the usable runway and not from a runway end that has a displaced landing threshold. I've observed many in the industry who do not quite understand that distinction. So it's important for you or your advisors to assess the situation correctly. Here's a diagram and plan view at the top and 3D view at the bottom of the FAR Part 77 surfaces. The chart of dimensions is hard to read, I'll grant you that, but you would note that the dimensions vary. In this example, north is on the top of the page. There is a precision instrument approach to the runway when landing to the east from the west. Accordingly, the large blue area extends for 50,200 feet for nearly 10 statute miles, beginning from the end of the runway. And at its end, it has a total width of 26,000 feet, or a little more than 5 statute miles. This gives you a sense of the volume of airspace that can be involved. This approach surface rises at a slope of 1 foot vertical for every 50 feet horizontal, so it is quite shallow. What the FAA is trying to encourage through FAR Part 77 is to keep objects below the surfaces associated with an airport. And typically, these surfaces are illustrated for the airport as envisioned in the next 20 years and shown in its approved airport layout plan, which may not necessarily be representative of current conditions. The FAA protects airspace for the airport as presented on its approved airport layout plan. It's important to keep in mind here that FAR Part 77 is really a trigger mechanism to establish whether there is a requirement to file a notice with the FAA. The FAA then initiates an aeronautical study to determine if an object is an obstruction, and if it is an obstruction, if it is a hazard. An object is an obstruction if it penetrates the imaginary surface, and that is a straightforward calculation. The full evaluation as to whether the obstruction is a hazard is conducted by the FAA using a very complex set of technical guidance that considers a host of factors that are relevant to the FAA's business modes. We're going to discuss this a little bit later on. However, it's very important, I'm going to say this loud and clear, it's very important for you to recognize that the FAA has no authority to regulate local land use. They strongly suggest to airport owners that they do so, but when applicable, to have them engage with the jurisdiction in which they are physically located to adopt land use and zoning regulations that protect these FAR Part 77 surfaces, as well as others that are associated with the use of the nation's airspace, from obstructions that are determined to be hazards. That is an obligation contained in the grant assurances that I mentioned earlier. We'll talk a little bit more about this in the webinar. Also note that nearly every state has laws and regulations that are based on the provisions of FAR Part 77. The nation's airspace is controlled by the FAA through the authority it has received from Congress. You're probably familiar with the terms instrument approach and departure procedures. What you may not know is how these procedures are developed and utilized for those flying into and out of airports. Basically, the design of these procedures are defined in a series of volumes that are collectively referred to as the United States Standard for Terminal Instrument Procedures, or TIRPs. Instrument approach procedures are comprised of segments, the initial, intermediate, final, and the missed approach. Unlike FAR Part 77, which uses the term object, TIRPs uses the term obstacle. And while it is desirable that obstacles not penetrate the imaginary surfaces that are prescribed by TIRPs, and which are not the same as those defined for Part 77, those that do and have the most impact on the design of each segment are called the controlling obstacle. Also, unlike FAR Part 77, the obstacle evaluation surfaces in TIRPs are flexible in their design. They can be offset from the extended runway center line, vary in their rates of descent or glide path angles, or incorporate multiple other features in the design that can be modified within acceptable aircraft operational limits. This affords your clients with an opportunity to suggest changes to an existing instrument procedure that can accommodate the proposed obstacle and not adversely affect the operational capability of the airport and its users. While FAR Part 77 is tied directly to the physical length and elevation of the full usable runway, TURP's approach surfaces are based on the elevation and location of the landing threshold, which at many airports is not the physical end. When completed, the FAA publishes an instrument approach and instrument departure procedure that is tailored to the obstacle environment of the airport. When the airport is located in an obstacle-rich environment, one can likely expect an instrument approach and departure minimums in terms of ceiling height and visibility to be higher than those in open and flat areas. If you have ever flown into airports in the Colorado ski resort area, you now know why sometimes the pilot cannot land in poor weather. The obstacle environment, which includes terrain, trees, and man-made obstacles, limits the height to which the pilot may descend to visually gain the runway and land the aircraft. So the aircraft diverts to another airport and you get bused to your intended destination. High approach minimums also exist in open and flat areas. For example, in the Philadelphia area at Philadelphia International Airport, the north-south runway was extended to the south to gain added operational capability and increase the capacity of the airfield. However, existing structures in the approach to landing to the north, including ships in the Delaware River, limit the use of that runway to when the ceiling is at least 427 feet or the visibility is at least 1.25 statute miles. This is higher than the lowest achievable approach minimums of 200-foot ceiling and a half-mile visibility because there is no approach lighting system on that runway end. So obstacles limit the true potential utility of the runway end despite the large capital investment made to lengthen that runway. This graphic is intended to give you a sense of the scale associated with the airspace protected by FAR Part 77 and an instrument approach procedure designed using TURP's criteria at the Pratt Industrial Airport in Kansas. The small line at each end of the arrowhead is the 5,500-foot runway at the airport. The yellow lines are the approach, horizontal, and conical surfaces or the Part 77 surfaces for that runway. The small trapezoidal shapes of the approach surface are rather short and not 50,200 feet, as we illustrated earlier, because the instrument approach to this airport, which is from the right side of the graphic, is not a precision instrument procedure, but a non-precision instrument approach, and the visibility minimum is 1 statute mile. The green lines depict from right to left the initial, intermediate, final, and missed approach surfaces that are evaluated for obstacles. You can see that these are many, many times the size of the FAR Part 77 surfaces. On this slide, we've highlighted the various FAR Part 77 surfaces, 2 instrument approaches, and the en route airspace that the FAA would evaluate for objects and obstacles. Not shown, just to keep the graphic less complicated, is the airspace protected for instrument departures and similar surfaces for the airport whose runway you can see at the bottom center of the graphic. The light brown lines in the center are the runways at the airport for which these surfaces apply, and those are about 1 mile in length. So you can gauge just how large the volume of airspace can be in effect at an airport. As mentioned earlier, FAR Part 77 serves as a trigger mechanism for the proponent to file notice with the FAA and for the FAA to initiate an aeronautical study of a proposed object. The regulation is quite specific as to when the proponent of the object must file their intent with the FAA. FAR Part 77 identifies obstacle identification surfaces and other standards that define the need to file notice with the FAA. The standards that require filing notice are more restrictive than those associated with the FAA's subsequent evaluation. There is distinction between publicly owned airports for which the proponent must file, and privately owned airports that are not covered by the regulation unless the FAA has published a public use instrument approach procedure to that airport. When there is a requirement to file notice with the FAA, the agency uses obstacle evaluation surfaces to find an FAR Part 77 and those associated with the use of the airspace, such as TERPs, in general to determine if the object is an obstruction and if so, is it a hazard to the navigable airspace. Once it is determined that the FAA needs to be notified, and if in doubt, file anyway, because the Secretary of the Department of Transportation can levy a fine of $25,000 if the proponent does not file and it was determined that such action was required. You file what is known as FAA Form 7460-1. As you might imagine, there's a form for everything, and you can do that online. It's rather straightforward. You need to tell the FAA the latitude and longitude of the object and the height above mean sea level and what the object is. The FAA then assigns an aeronautical study number to the object and starts the evaluation. By the way, if your client is proposing to install 100 wind turbine generators, a Form 7460-1 needs to be filed for each. The FAA receives over 3,000 of these forms for all sorts of objects every year. The aeronautical study considers the FAR Part 70 surfaces, impacts on instrument approach and departure procedures, en route airspace that could affect minimum safe altitudes, for example, and electromagnetic interference with communications facilities. The FAA also looks at possible interference with radar facilities used for aircraft surveillance, weather, and national defense and security. On this slide, I'm just mentioning here again some of the various airspace issues that can be affected by an obstacle. And these are just some of them, the minimum vectoring altitude or instrument approach minimums. There's a host of them. You need to be cognizant that the airspace covers a large area around airports. It's not just the immediate vicinity. Some obstacles quite distant can be an overriding factor in making a determination. The FAA can modify procedures based on the results of its evaluation. However, they don't tend to do that. It's just something that's not their business. It's easier for them to say, you've got a problem, and you deal with it, and then come back to us with a better solution. So in that vein, you should be determined. You should evaluate your options to avoid and mitigate against any adverse airspace impacts, and be proactive and present solutions to the FAA in advance and allow them to what I call wear the white hat and let them show you that we can find win-win solutions, or that they can find these win-win solutions, and everyone can be copacetic. That goes a great way in making your client's projects move forward. Now, in the FAA Part 77 and study process, this is what they could actually result with. First, they could issue a no hazard determination, which is what you'd like. They could issue a presumed hazard determination, which implies that there is a problem, but they're looking for you to investigate opportunity for mitigation measures. You can then propose those measures, and then they will issue a final determination, and if you're still not happy with that determination, you have the opportunity to appeal. Again, the FAA cannot prevent you from implementing the proposed action. That is governed by local land use and zoning regulations. If you do build it, the FAA has no choice but to modify the use of the airspace to accommodate the obstacles safely. This could generate ill will with the flying public. Most developers don't want to have that outcome, but trying to find mutually beneficial mitigation measures is preferable. One outcome that you should know about is the long-standing agreement between the FAA and the Federal Communications Commission. That agreement provides that if the FAA finds a communications facility that requires the issuance of a frequency controlled by the FCC to be a hazard to air navigation, the FCC will not issue the license for that frequency. This renders the communications facility unusable and of no value. If your obstacle does get a hazard determination, it could be a liability in the event of an accident or incident. That happened in a case I'm working on now. An aircraft hit an object when departing that resulted in a fatality and serious injury to the people in the plane. The object was not made known to the flying public on charts or other commonly used data sources. For pilots and the owner of the object did not file with the FAA for an aeronautical study. The plaintiffs in this case have several parties to sue in reaching a settlement of what will likely be multi-million dollars of claims. Another outcome is that the FAA could find that the airport owner is not complying with the grant assurances and could deny future grants for airport development and improvement because the airport is not doing what it needs to protect the airspace. This outcome is not conducive to your client maintaining good relations with the airport, and as a public entity, the airport can be an important proponent for your client's proposed development project. Some sort of compromise mitigation should be seriously explored in these instances. Finally, some local jurisdictions will not issue a building permit in the event your client's proposed construction is determined to be a hazard. So mitigation on your client's part to obtain a less severe determination from the FAA, there's no opportunity for that. So that's about the gist of what I'd like to convey in my portion. I'll turn it back to Matt for some Q&A, and hopefully you'll have some interesting comments and questions. Thank you.
Okay, excellent. Thank you so much, Ron, for your portion of the presentation. Henry, you should be unmuted and on the line now. Can you just give us a test 1, 2?
Yes, test 1, 2.
Loud and clear. Ron and Henry, and to all who are in attendance, we'll be taking our first Q&A break here. If you want to submit a question, please use the chat feature or Q&A feature found on the right-hand side of the screen to submit your questions to the presenter. Ron and Henry, we do have a couple questions in the queue that we'll get to right now. In February of this year, the President signed into law the FAA Modernization and Reform Act of 2012. Are there any key provisions that the attendees should be aware of with regard to airspace requirements or any rules and regulations that are on the horizon?
This is Ron speaking. I'm not aware of any. The law, provided additional funding. That was one of the key things that the industry was looking forward to. Pretty much left everything intact. I know there were some issues related to mineral rights at airports and how they could be exempt from some of the revenue provisions that airport owners and sponsors that are obligated need to comply with. And that's about the only nuance that I'm aware of.
Okay, excellent. For Ron and Henry, during the first part of the presentation, you talked, or you gave examples of large airports like Philadelphia International Airport. Do small local commuter airports face the same sort of issues, or are there unique issues that are very different from the large international hubs? No, every airport's treated the same. The only difference is the size of the airspace areas that need to be protected. As you might imagine, Philly International has instrument approach procedures, precision to all the runway ends. Their surfaces go out quite a ways. Small community airports may not have an instrument approach, but they all have FAR Part 77 surfaces. Okay, excellent. Are there any, Are there any issues that Ron, that you're seeing as land developers and airport owner-operators try to work as one to benefit the community? Are there any issues that are emerging right now that you're seeing as a trend in either litigation or in just kind of disputes?
I can tell you that lately I've had a lot of items come across my desk, and they involve trees in the vicinity of airports. Typically, close in and large areas of trees, some of which are very valuable because they're specimen-type trees. Lately, there's been a flurry of that kind of activity, and it presents a very important or interesting, challenging assessment because you have the problem that the FAA establishes these surfaces and objects become obstructions, and obstructions become hazards, but they leave it up to the local airport owner to enforce them, and if they are not the same as the jurisdiction in which the airport's located, it makes it very difficult. Some communities just don't work very well with their local airport that's located within their jurisdiction. So you have hazards, but no teeth from the FAA to do anything about them, and it becomes a discussion, sometimes vociferous arguments about, is the airport more important than this bunch of trees that are on the approach? And so that lately has been cropping up. Not to use a pun.
Oh, yeah. Okay, great. I don't see any other questions in the queue. So, Henry, we're going to turn the presentation over to you. You are now the presenter.
Thank you, Matt, and welcome to all the participants. Sound is defined as a vibration, a fluctuation of pressure in the air, typically in the audible frequency range of human hearing, which is 20 hertz to 20,000 hertz. There are three properties of concern: pitch or frequency, amplitude or volume, and the duration of the sound. At this particular moment, I want to remind you that I've prepared a separate publication which discusses all of these matters in somewhat greater detail than I'm able to do from these slides. Noise is characterized somewhat differently than simply sound. Noise typically is defined as unwanted. It is also usually random, often sudden. It is considered at high amplitudes to be intrusive, disturbing. It may, for example, create speech interference events. It obviously may create sleep interference events, and may otherwise create conditions of annoyance and anxiety in the listener. The original concept under which our regulations were based were formed from the realization that the primary pathology associated with exposure to excessive sound and noise is hearing loss. Hearing loss is cumulative over a lifetime. Generally, the standards that exist are sufficient to protect against hearing loss for people who live off airport. Hearing protectors are not required, but they most definitely are required on airport where amplitudes, particularly on a ramp, can be quite excessive. I want to take a moment to mention repetition. Many noise events, in and of themselves, a single event, is not particularly disturbing. But a great many residents that live near airports have to cope with repetitions over many weeks or months, sometimes as long as 6 months without a change. Even low volume or low amplitude sounds repeated sufficiently frequently, or repeated, for example, during leisure periods, in evenings, overnight, and on weekends, can be especially annoying to airport vicinity residents, and accounts for the fact that airport noise is one of the chief reasons why it is difficult to establish new airports or to expand existing airports. There are other health effects that have been noted, particularly in research in other countries, Europe notably, over the last 20 or 25 years. And the standards that have been set internationally are somewhat more sensitive than the standards that are typically applied here in the United States. Thus, be aware of the fact that there can be numerous complaints from numerous individuals in areas which nominally would be considered compatible with airport operations. Background noise levels in particular have an effect on how noise from aircraft is perceived. In a typical urban situation, and most of the regulations were based upon surveys done in urban areas where there are relatively high levels of background noise that tend to mask part of the noise that occurs during an aircraft flyby event. Whereas in rural communities, in communities that have low ambient noise levels, several things occur. First, the noise event seems more prominent. It seems louder. Second, the event duration is extended because the onset point is much farther away from the listener and is not being masked by background sound levels. This is why you can have serious noise problems even at airports that are quite small and that don't necessarily host the volumes of traffic found at major air carrier facilities. We're going to discuss noise metrics. This is a complicated topic, and it is discussed in somewhat greater detail in the handout that I've prepared that can be downloaded to accompany this presentation. The fundamental unit of noise measurement is the decibel. It sounds like a contrived word. It is. It comes from the root the bell, which is an order of magnitude change in the level of energy in the sound or noise event. The decibel, by the way, is typically going to include being filtered through one or another weighting scheme. The purpose of the weighting scheme is to simulate the different sensitivities of the human ear that occur at different frequencies and at different amplitude levels within the noise signature. The commonest one that you see, and the one typically applied for all environmental noise measurements, is A weighting. There is B weighting, and most importantly, there is C weighting. A weighting simulates the sensitivity of the human ear at normal listening levels, and at normal listening levels, the sensitivity of the ear to high frequency and low frequency sounds is somewhat attenuated. C scale is the scale that removes that attenuation that's built into the circuitry of the measurement meter. It is linear, it is flat, and thus those are the two that we most frequently run into when we do noise measurements and measurement studies. We're most concerned in measurement with the peak noise level. The peak noise level may be quite brief, but the maximum level, termed Lmax, is the one that we use to determine which aircraft are noisier than other comparable aircraft in the fleet. The concept of the single event level is extremely important in understanding how the mathematics of all of this works. In assessing aircraft noise, what is done is that the entire volume of noise that's emitted by an aircraft during a flyby is condensed into a 1-second long reference duration event. Thus, it permits us to determine at varying distances and with differing aircraft what the, so to speak, unitary emission of noise is from a given aircraft. These can then be added together relative to a specific location and divided through by the number of seconds in the day in order to get the annual average, or the daily average, which typically represents the annual usage of the airport. In adding and averaging noise, one must be very careful about approaching the mathematics. The decibel is a logarithmic unit. It is not linear, like an inch or a mile. Rather, it is a pressure ratio that is shown on a logarithmically varying scale, in this case multiplied by 10. Thus, 60 decibels is 10 times more powerful than 50 decibels. But two sounds added together at 50 and 60 decibels do not make 110. The numbers must be converted into real numbers, not logarithmic numbers, for any manipulation that you wish to do in the sense of averaging, multiplying, or finding cumulative levels of sound over a given period of time. This is reflected in the official method for determining noise around airports. It is known as the day-night average sound level. It is abbreviated DNL or LDN. It is the single designated system under federal law for assessing noise impact around airports. It was originally developed by the Environmental Protection Agency in the 1970s. It has significant limitations as a descriptor, although it also is the state of the art and a reasonable way of indexing noise impacts between differing airports. However, there can be an infinite number of ways that we can arrive at a given DNL or LDN number. It could be composed, for example, of relatively few extremely noisy events or a large number of relatively small events, and this has a dramatic effect on how people perceive the noise environment around an airport. One last concept that needs to be mentioned is loudness. The human ear does not respond to sound or noise in the same way as a sound meter will. The human ear, because it has an extremely long range of sensitivity, the softest sound being somewhere between 0 and 20 decibels, the loudest sound in the A scale that can typically be comfortably heard is 120 decibels. After that, you really get to the threshold of pain. But that represents a spread of several billion in terms of pressure level from the lowest to the highest. The human ear responds to the 10 decibel interval that I mentioned earlier as a doubling or a halving of the sound, and not as the order of magnitude increase that the mathematics suggest applies in the decibel rating system. The noise measurement process. When you are evaluating a given site or the reactions of a given individual or the appropriateness of the structural noise attenuation in a given structure, it's extremely important to make on-the-spot measurements. It provides, first, documentary evidence of what actually occurred. They should be conducted ideally over a reasonable period of time. In the context of a scientific study, at least 2 weeks of measurements are considered the minimum that would be an appropriately reliable figure. Noise measurements are typically conducted either by manned observation with a handheld meter, or there may be an automated meter that can be set up and deployed in a vehicle and left on station for long periods, Or, in the case of many airports that have noise monitoring systems, they have permanent microphone locations at specific spots in various places around the airport, typically under or near the flight tracks, and thus long-term statistics on noise impact are accumulated. The statistical output of noise measurements includes much more than simply the peak level that I mentioned earlier or the DNL or average noise measurement. They include the background noise level, and the background noise level is typically defined through percentile readings, and there is one state in the United States that also uses percentile readings as part of their regulatory scheme. What a percentile reading for the background noise level represents is the L90, which is the point at which 90% of the samples that have accumulated are at or above that level. So what it is doing is telling us what the lowest 10% is of all of the samples collected. And that is typically the index that is used to determine the background noise level. There are limitations on all of these kinds of measurements. You will rarely find two noise meters that precisely agree. And in particular, you should be aware of the fact that there are three levels of noise meters: Type 3, Type 2, and Type 1. A Type 3 meter is the least accurate, but it is substantially more accurate than the human ear. Type 2 meters have a higher level of accuracy, although most of the measurements that are done professionally are done with Type 1 meters. These are much more expensive instruments and need to be calibrated before and after use, and typically are lab calibrated at least once per year. All of this is a way of approaching the subject of aircraft noise and compatibility. We typically do that around airports by using a model. The integrated noise model, in this case, is provided by the FAA to licensed users. It is an FAA and industry standard. It contains all relevant information with respect to a representative sample of aircraft types within its database. The input requirements that are determined by the operator include the types of aircraft or fleet mix, the volume of movements, typically on an average daily basis, the time of the day. In the case of DNL, there is a 10 decibel penalty for all noise events that occur between 10 p.m. and 7 a.m. It is thus different than a straight average. You also specify runway use and flight track use based upon the annual distribution of traffic amongst the various runways and flight tracks. I'm going to show you some of the output, but the limitations of the output should be kept in mind. They may or may not correlate well with annoyance levels and subjective impressions of people who are the receptor population. DNL, and you'll see this in a later slide, is the accepted point for the onset of significant noise impact. The FAA, as a practical matter, considers all residential uses below 65 DNL to be compatible. It is also the threshold for FAA mitigation funding, including awards for insulation or for the acquisition of property. Thus, DNL 65 is the key criterion in understanding noise around airports. It is also a fact that for most airports within the United States, particularly air carrier airports, DNL 65, due to the reduced source noise emissions in aircraft that have occurred over the last 30 to 40 years, have been withdrawn onto the airport itself or into land adjacent to the airport that the airport owns. Thus, it will be rare that you will encounter a situation where a given residence or a given individual remains within DNL 65. One would presume that that would mean that the problem has been extinguished, but that is not the case. In fact, where noise is a serious problem around airports, for those people, the situation is now worse than it was years ago. These determinations are typically done in the context of a Federal Aviation Regulations Part 150 noise study. That is a prescribed process of determining existing exposure, future exposure in 5 years based upon forecasted changes in traffic, and a series of proposals that will modify, reduce, or mitigate the impact that occurs around the airport. A program is thus devised and submitted to the FAA, and the components of that program evaluated by the FAA with respect to interstate commerce, and they may or may not agree to several, all, or none of the proposals submitted to abate noise. You also encounter noise impact determinations, typically via computer, in environmental impact assessments, and this can also be a point where great concerns amongst the public arise. What you see in this slide is the actual federal land use compatibility table that's drawn from FAR Part 150. You will note as we get above 65 in the first line, residential land uses are not considered compatible above 65, except that there is a footnote that indicates that the noise insulation requirements, if properly met, can turn an incompatible use into the compatible category. And grant assistance is available from the FAA for accomplishing such noise attenuation insulation. However, be aware of the fact that, generally speaking, there is an improvement, but it is not sufficient to be satisfactory for many individuals. In other words, they are dealing in noise insulation with averages, and on average, the noise insulation is helpful, but does not necessarily, in the opinion of the occupant, reach a level of attenuation that is acceptable to them. I'm going to show you in the next few slides a variety of different noise contours from different sized facilities so that you have a feeling, number one, for how the size may vary between large and smaller airports, and number two, the different styles or formats of presentations that are typically used in these kinds of determinations. What you see on your screen is at Hartsfield Atlanta International Airport, which is the largest airport in the country right at the moment by passenger volume. The outer contour is in purple, marked 65. The inner contour at DNL 70 is in green, and the DNL 75 contour is in red. Be aware of the fact that federal policy asserts that all areas exposed to DNL 75 or above levels of noise are eligible for acquisition by the airport with assistance from the federal government. On this slide, which by the way, north is on the right, the nature of the north-south runways are such that to fit this on the screen it had to be rotated 90 degrees. So it's not viewed as you might expect. This is a medium hub airport, not a large hub airport as in the case of Atlanta. You will note that they have plotted the outer contour, the red line that you see, that's DNL 60. In other words, the custom, because of some of the reasons that I'd mentioned earlier, of stopping at DNL 65 really means that you do not depict or address areas outside of 65, and most noise complaints, believe it or not, at airports originate outside of DNL 65. This is a much, much smaller airport. This is Nantucket Airport. You note that the style of presenting the contours is much different. We use solid colors, in this case translucent colors, to illustrate the areas that are being adversely impacted. You will notice in this particular case that these are also plotted down to DNL 60. You will also notice that there are certain homes that are adjacent to the airport on the east and the western side. And there is considerable adverse reaction because there's a lot of commuting that goes on at Nantucket Airport, and the crews tend to come in early in the morning and leave in the evening, generating unwanted noise events. We're now going to move to the smallest of the noise contour displays that I have to present. These are the annual average noise contours in East Hampton. You would think that with such a small area involved that there would be relatively little adverse effect, whereas quite the opposite is the case. And you will see in the next slide why. You will also notice in this display that I plotted the contours out to DNL 50. In other words, 15 decibels below the federal threshold of compatibility. The reason why that we have problems at that airport is revealed by the following slide. This is what the noise impact looks like on a busy summer weekend day. Notice how much larger the area of influence is. Realize that in a resort community like East Hampton, the time of greatest sensitivity occurs during the summer months when the noise impact tends to peak. This was prepared as a decision-making tool for the local government to understand why they get so many noise complaints. In the year 2008, East Hampton had over 8,000 noise complaints. Noise complaints have diminished somewhat since, but you do not have to have a large airport in order to have a significant adverse effect on the local community. One of the most frequent requests from annoyed individuals is the establishment of access restrictions. This matter became sufficiently difficult as an operational consideration for the airlines that a law was passed in 1990, and subsequently FAR Part 161 was established. When Ron mentioned earlier in the presentation Naples, Florida, it remains the only airport that has fully gone through the Part 161 process and emplaced access restrictions. There is no legal right to establish airport access restrictions other than through complying with the requirements of FAR Part 161. There are numerous cases that are special exceptions to the matter of compatibility. The first and most prominent of which are the impact of noise upon schools. And that can be sufficient in some cases to actually reduce the performance of the students one grade level below what they would otherwise achieve. Hospitals and medical facilities can also be extremely noise sensitive. You would presumably include old age homes, retirement communities, and other places where people reside 24/7 as being particularly noise sensitive. Recently, wind turbines have come up as a controversial matter with respect to their noise impact. And in particular, you should be aware of the fact that wind turbines tend to produce infrasound, sound and vibrations below the level of normal human hearing. These can be exceptionally annoying. The consequence is that you must provide large standoff differences between wind farms and adjacent residents, typically on the order of a mile to a mile and a half, in order to avoid adverse effects. Churches and other places of public assembly can also be extremely noise sensitive, particularly outdoor places of assembly, amphitheaters and the like. All of these cases require and need special treatment and understanding in order to achieve actual compatibility. There are really only three ways to reduce noise impact. The first way is to reduce the source noise level. This has been part of what has happened to the aircraft fleet over the last 30 to 40 years with the advent of ever quieter aircraft engines. We have reduced the noise signature at the source, although for large aircraft they still emit sufficient sound to create unwanted noise events in the proximity of airports. The second thing that we can do is to increase the distance between the source and the receiver. This is the strategy of using preferential runway use or preferential flight track use or other means to assign aircraft into flight paths that lead away from populated areas. The third and final way is to protect the receiver. This is typically done through a sound insulation program such that the interior areas of a given home, and in particular the bedrooms, are well insulated. And I see we're very close to the end of our presentation, so we'll go as quickly as we can through the last few slides. The thresholds of significance, the losses in value, a taking frequently occurs, and under nuisance law, there is also a liability that can be exploited. You may also encounter misapplication or misrepresentation of noise impacts. The future trends will reduce noise and air pollutant emissions, but we're reaching the point of diminishing returns. International concerns and reduced exposure limits are a continuing problem. Airport noise has generally been a topic confined to airports, but through the establishment of RNAV routes and route noise is a growing concern. All of these areas present opportunities for increases in litigation. The FAA has determined to try and categorically exclude these matters with respect to the establishment of airways throughout the country, and this is causing considerable adverse reaction because the health effects are becoming much more well known amongst a much larger body of individuals. The lawyer's obligation is to foresee all that is foreseeable. Here we are considering the ability to have foresight about spatial clearances and noise, both of which are essentially invisible. Thus, it requires an understanding of the regulatory environment, a verification of the facts, the consideration of mitigating measures and alternatives in the development and the legal processes. And experience and insight is the only key to a successful course of understanding and litigation. Matt, I'll turn it back to you.
Okay, great. And Ron, you should be unmuted and on the line as well. Ron, are you there?
I'm here.
Excellent, Ron. Okay, I see two questions in the queue, so we'll get to those very briefly, and then we will wrap up this afternoon's program. Henry, with respect to the noise incident or the noise issues at large, medium, and small-sized airports. Is there a common point of contention, or is each unique?
Well, no. They are not unique. In other words, the pattern of reactions tends to be the same in a number of different circumstances, but because there are differences in individuals, differences in the regulatory structure in the sense of who owns the airport and who controls what's going on, that you will encounter variations such that each individual airport tends to be a special case, although the issues tend to be the same airport to airport.
Okay, excellent. And the final question for both of you, Ron and Henry. Looking at this issue, it seems that there are, 2 or 3 parties that are involved in most of these issues. You have the airport owner-operator, you have the local government, and you have, probably 3 or 4, you have the landowners and or developers. What would be your advice to each of those groups to mitigate some of the issues that arise, both with sound and with development?
I'm going to respond to that in a somewhat indirect way. We'll start with a developer. It is often the case around airports that the things that make an airport possible, the municipal services, roads, sewer, water, also make those areas conducive to development. If they are developed, it is perfectly feasible to make those structures entirely compatible. The key understanding is that one has to invoke techniques in building construction and design that are well over and above the levels that are specified by the FAA. Those measures are satisfactory, but they will not lead, for example, to marketable interiors. Generally, you are encountering an area where planning and zoning and other personnel on the municipal level are not well versed in the effects of noise. Thus, it's a job that one has to do for oneself as opposed to a job that is going to be done through compliance with building or zoning codes. In any event, it is hazardous in the sense of marketability to build structures near airports, and caution is advised in all circumstances, as well as the participation of individuals skilled in understanding noise and the construction techniques that are used to mitigate the effects.
Yep, and I'd like to add about obstacles in the airport environment. I guess the critical thing is for the parties to really understand what they're talking about, to be cognizant of what the definitions are and how they're interpreted and how they're applied. There's so much misconception out there that it's almost sometimes amusing to be a party to it. Basic law is just not taken into consideration, and there needs to be, I think, a common understanding of the value of the airport and the value of the surrounding land areas and how they can both work to satisfy the community. Also recognizing that the FAA is not the ultimate authority. They, in fact, have absolutely no land use control regulatory capabilities. And that fact is always lost on the participants. So know your definitions, know what you can and can't do, and you can make things happen and find those win-win solutions.
Excellent. Ron and Henry, on behalf of all the attendees and everyone here at TASA, thank you for the time and the effort that you put into this presentation. I think everyone in attendance was able to take away a lot of very, very useful information. So thank you for the time and the effort that you put into the presentation. I'm going to now wrap things up just very briefly. I want to thank everybody who took time out of their day to spend an hour with us to talk about this issue. If you'd like to speak to Ron or Henry about a specific case that you're working on, please contact us here at TASA. Our telephone number is 800-523-2319. As I indicated during the introduction, we will be sending out a link to the archive recording of this webinar tomorrow morning. Please feel free to share that with your colleagues. We'll also include in that email links to the PowerPoint presentation and the sound supplement that Henry referenced during his portion of the presentation and I sent out during today's presentation. The archive recording of this program, as well as all of our previous programs, can be found in the Knowledge Center on TASA's website. Visit tasanet.com and click on the Knowledge Center tab found at the top of the page. Our next webinar for legal professionals, 3 high liability issues with the management of special needs students, will take place on June 5th, 2012 at 2 p.m. Eastern Time. Look for an invitation to that program from me shortly. And if you have any follow-up questions or comments, we do take all of your comments under consideration and they help us to produce better programs. Please feel free to shoot me an email at mhi@tasanet.com. With that, again, thank you to Ron and Henry for the effort that you put into this. I will conclude today's program. Thank you so much.